I'm going through a divorce and wonder if I can pay my lawyer on a contingency fee basis, where my lawyer would get a percentage of the amount of alimony I'm awarded or the amount or the value of the property I might be awarded. Can I do that on a contingency fee basis? Well, I can't answer for all jurisdictions, but in Utah, the rule is, as provided in Utah Rules of Professional Conduct 1.5D1, quote, "A lawyer shall not enter into an arrangement for, charge, or collect any fee in a domestic relations matter, the payment or amount of which is contingent upon the securing of a divorce, or upon the amount of alimony or support or property settlement in lieu thereof," close quote. So divorce attorneys cannot take a case on a contingency fee basis. Divorce attorneys can acquire an interest in a client's property through an attorney's lien, but that's when the client doesn't pay. In a Bar Journal article from the Utah Bar Journal of 2014, there's an article by Keith Call that explains the attorney lien rule clearly and succinctly. A lawyer shall not acquire an interest in the cause of action or subject matter of the litigation except that the lawyer may 1. Acquire a lien authorized by law to secure his fee, and 2. Enter into a reasonable contingency fee arrangement in civil cases, but as I mentioned, divorce cases don't count. A lien authorized by law, as described in Rule 1.8, includes the statutory attorney's lien in Utah Code Section 30-2-7. By statute, a lawyer automatically receives a lien on any money or property that is the subject of or connected with the work performed. 38-2-7 provides that this includes real or personal property, funds held by the attorney, or any settlement judgment and proceeds thereof. The statute includes limitations on pending criminal and domestic relations matters. The statutory attorney's lien is not a business transaction with the client and is therefore exempt from the requirements of Utah Rules of Professional Conduct Rule 1.8a. Now, the Ethics Advisory Committee for the Utah State Bar has further opined that given a lack of clarity in the extent of an attorney's statutory lien rights, lawyers should not be subject to discipline for asserting lien rights according to a good faith interpretation of the statute. The statutory attorney's lien commences at the time of employment. Notice of the lien can be given by filing a notice of lien in a pending legal action in which the attorney performs services, or in the case of real property, by filing a notice of lien with the county recorder. To enforce a statutory lien, a lawyer must first demand payment from the client. If the client fails to pay within 30 days, the lawyer can move to intervene in the case in which the attorney performs services, or the lawyer may file a separate legal action to enforce the lien. Utah Code Section 38-2-7 sub 9 provides, quote, "This section does not authorize an attorney to have a lien in the representation of a client in a criminal matter or domestic relations matter where a final order of divorce has not been secured unless A, the criminal matter has been concluded, or the domestic relations matter has been concluded by the securing of a final order of divorce, or the attorney-client relationship has terminated, and B, the client has failed to fulfill the client's financial obligation to the attorney."